I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your boy TP. Today, we're going to be doing something a little differently. We've been here on YouTube now for 4 to 5 months, and I must say, guys, the support has been amazing. And in that time, we've been able to get up a good amount of videos, shared a good amount of proceedings. So what I wanted to start doing was going back and sharing some of those proceedings in like a compilation, some of those classic proceedings. So today is going to be the first time that we are going to do that. And we're going to share a 4 proceeding compilation on today. And the judges that's going to be in this compilation is going to be Judge Sheila Johnson, Judge David Wolf, Judge Simpson, and Judge Shawn Perkins. These are classics. Some that some of you have seen, some of them you may have not seen. If you've seen it, just skip on to the next one or enjoy it all over again. And if you haven't seen any of these, then it's definitely going to be a blast for you. But with that being said, I'm going to get out of the way so we can go ahead and jump into these proceedings.
Mr. Harris, would you please come to the podium?
I challenge jurisdiction.
Mr. Harris, I need you to step to the podium.
If I step to the podium, it'll be under threat, duress, coercion.
Well, fine, just do it.
Okay, no problem. But I'm here, I'm at the podium under threat, duress, and coercion. Other than that, I challenge jurisdiction.
Okay.
Without prejudice, I, Mikael Eric Colin Harris, beneficiary and sovereign principal, am here under fraud, threat, duress, coercion, and extortion fiduciary, Ms. Sheila Johnson. This is a Social Security Cessate Trust action in which you are now a real party and interest to. This is a military admiralty tribunal and maritime law. So you accept the challenge of the jurisdiction.
You can challenge it. I'm not stopping you from challenging it.
Do you accept the challenge?
I don't know what you mean by accept the challenge.
Do you accept that this is a maritime admiralty law?
No.
You don't accept that?
This has nothing to do with admiralty, sir. This is simply a charge that you're here for.
Yeah, but
it's nothing to do with the sea, vessels, or anything like that, which are boats. Admiralty law applies to that.
Yes.
This right here is a driving a car offense. And it's a 93-day misdemeanor carrying up to $500 fine, and it carries a possible suspension of your driver's license, additional points to your driver's license, and possible vehicle immobilization of any vehicle that you're driving. That's what this charge is, and it's not admiralty law. You're using language that legally doesn't make sense for what we're here for.
But all this is a corporation.
Okay.
This is not are you saying this is not a corporation?
Sir.
I'm asking.
I have no idea what you're even talking about.
But I'm asking you a question. I mean, it is not maritime admiralty law, and
it's not maritime law.
Is it
no.
Now that Judge Johnson has that out of the way, she says, listen, Mr. Harris, it's time to run down these charges.
I'm telling you what I know doesn't apply.
Right. I never said that, though.
Okay. What
I said is I am a sovereign principal, and I am the beneficiary.
Well, sir,
you are fiduciary.
I'm telling you that what you are, as whoever you are, is charged with today. Now, you have certain options here. You can certainly have a trial if you want a trial on whether or not you are operating a motor vehicle without a valid license from the state of Michigan because it was suspended.
I object. I've equipped you with all the information you need to show down the sovereign principle, and also to show you in your constitution, it says that I can travel.
Sir, if you want to file a motion, file a motion.
Okay,
because no one can respond to all of this. Whatever you're saying, he can't respond to it.
I motion that you
have to file it in writing and cite your authority under law.
I did that.
And if you want to do that, you can do that. Otherwise, we're going to have to set your case for trial.
Under a Power of Appointment Act of 1951, I appoint the judge, executive. I would like y'all not to breach a contract. Breach of duty, breach of fiduciary duties.
Give me a jury trial date.
May 9th.
May 9th, 8:30. If you need to file a motion between now and May 9th, you better do it before the end of March.
Have a great day.
All right, good morning. We're going to go through the docket as quickly as we can so that we can start on the jail docket. 2021 CR 19158, State versus Matthew Aldridge. Are you Matthew Aldridge? Are you Matthew Aldridge?
I'm the attorney of fact for Matthew Aldridge.
You were what?
The attorney of fact.
Attorney what?
Of fact.
Attorney of fact. And what does that mean?
You know, his authorization to do legal representation.
Are you a licensed attorney?
No, I'm simply an attorney of fact.
Okay. And does that mean you have a power of attorney? What is your name? What is your name?
My name?
Yes, sir.
I don't have.
You don't have a name? Pardon?
I'm the attorney of fact for the respondent in the area.
Well, let me explain to you. Only an attorney at law can stand in court and represent a criminal defendant. And to do so otherwise violates the criminal law statutes of the state of Tennessee and could land someone who attempts to represent themselves as an attorney at law in serious trouble. I understand what you're saying. I understand you're saying an attorney in fact. And what I want you to understand is that if you have a power of attorney, then you need to demonstrate that power of attorney. Do you have a legal document called a power of attorney?
No, I do not this time.
Okay. Then you don't have any authority to act on behalf of Matthew Aldridge in this court. You have no legal authority, nor do you have any authority through a legal document to represent or to act on behalf of Matthew Aldridge.
Why don't the court just let me file this document?
Show it to the bailiff and he'll show it to me.
Have a copy of it.
Oh, apparently there's a copy here. All right, this is in the state of Tennessee of Cheatham County and Chancery Court, which is filed in the wrong county because in the wrong court, because this is circuit court. You just be quiet.
You go to the courthouse, it comes up.
You need to listen to me instead of talking, okay? This is a challenge to the standing. The Supreme Court of the United States has stated that no corporation has standing anything to man. And then there's a quotation for Rundle versus Delaware Raritan Canal Company. And then it says, as well as it being a maximum of law, citing certain Latin phrases, dissimilar things ought not to be joined by a definition of Black's Law Dictionary. So the respondent in error requires that the state of Tennessee Incorporated and Cheatham County Chancery Court prove their standing to proceed against a man in any court of law. You have 15 calendar days to prove your standing or forever yield to estoppel, waiver, and fraud, and cease and desist this proceeding immediately. More time is available if requested. And then this was signed by Matthew O'Neill Aldridge. Is that your signature?
That's the respondent in error signature.
All right. Well, I find that Matthew Neil Aldridge has failed to appear personally in this court for the plea day on his case, which was set for trial tomorrow. And as a result, you have no standing, sir, under what I know what you're trying to do is to try to use the sovereign citizen approach to this situation. And I'm simply telling you that you do not have the right to represent Matthew Neil Aldridge. If you are in fact Matthew Neil Aldridge, then you need to say so and stop this nonsense, because what you're attempting to do has no legal effect. You cannot challenge the criminal law or the jurisdiction of this court by simply filing some legal mumbo jumbo having to do with civil litigation. That has civil litigation in it. It is not a criminal case that you have cited. So it has no effect on this court. regarding the criminal statutes of this court. This court is empowered under the Constitution of the United States of America and the Constitution of the State of Tennessee, and by the duly elected citizens of Cheatham County to empower and enforce the laws of the state of Tennessee. And that is what I'm going to do regarding Matthew Lynn Aldridge. Mr. Aldridge is set for today to appear in court personally on what we call our last plea day before his trial date tomorrow.
Is that an Article 3 trial?
To what?
Will that be an Article 3 trial? A trial by jury with jury?
It would be a trial by jury, certainly it would be. But I don't know who you are. And I don't think you have any authority if you are not Matthew Lynn Aldridge to appear before this court. And you're wasting valuable time to all of these other citizens who are here today. So when I'm talking, you stop talking. No, you will when I'm finished talking. You are wasting the court's time by doing this, and I'm just simply instructing you that if you are in fact Matthew Lynn Aldridge, then this is your last day to settle your case. The trial date is set for tomorrow, and unfortunately it will not go forward because of the fact that I have a conflict and I have to be in Stewart County on a civil matter. So we're going to assign a new trial date for Matthew Lynn Aldridge. Now, is there a problem with the jury warrants? You put a notice up there for them tonight, if we don't need you tomorrow, but we need you on February the 6th. February 7th would be a day I could give it. Is that possible? General, we're going to need to set a trial date in July.
July 15th.
I'm sorry.
July 15th.
July 15th. All right. To Matthew Aldridge and the individual standing before me, whose name must not be uttered, then we will set a July 15th trial date for Mr. Aldridge. Whatever this document is that you have filed is in fact invalid because it does not cite any valid criminal statute, and therefore I'm denying whatever that might be in the way of a motion. The trial date will be July 15th. The last day for Mr. Aldridge to enter a plea or go to trial will be July the 8th. July the 8th. Now, we're going to give you a card. If you are in fact Matthew Aldridge and you're just playing games with the court regarding this nonsense that you filed, then you may get this card and you may go on about your business. If you are not Matthew Aldridge, then I would suggest to you, you relay to Mr. Aldridge that he must appear on July the 8th, or a bond revocation will take place, and his case will be set, will take place with him in jail, incarcerated on the 15th. That's the judgment of the court. You need to take your piece of paper and go on about your business. 2021 CR 19158 State versus Matthew Aldridge. All right. I've been handed a document that states, I, the attorney of fact, there is a ruling $25 I'm asking what form of exchange is acceptable. Also, is the trial going to be about trial by jury on the 15th of July? Only a bar member is able to respond by mail. Jacksonville, Tennessee, United States of America, zip.
Well, my address, the address,
Pardon?
rather have the address private, with you, of course.
Microphone up so I can make sure I'm here. You're going to have to speak up. We've run through this before. Are you, in fact, Matthew Aldridge, acting as your own attorney?
I'm in fact, I'm the attorney, in fact, for Matthew Aldridge.
You're the attorney of fact for Matthew Aldridge.
Yes.
Right. Now, you understand Matthew Aldridge is required to be here today because his trial is next week. And if you are Matthew Aldridge, then this is your last day to settle your case by any sort of an agreement. Otherwise, you're going to go to trial next Monday, is it?
The 15th.
All right. You'll be going to trial, and it will be a jury trial. And
Yes,
you're
okay.
going to represent yourself, correct?
Correct. Yes, correct.
All right.
Correct.
And we will show that you are to be here Monday. Raise your right hand. Let's place you under oath. I just want to ask you a few questions on the record. Raise your right hand. Let's place you under oath.
Yeah, affirm.
All right. How old are you?
I'll be 40 this August.
40. All right. And how far did you go in school?
I graduated.
All right. From high school?
Yes,
All right.
high school.
Have you
graduate.
familiarized yourself with the rules of criminal procedure?
Yes, I have been.
All right.
Yes,
So you understand what the rules are regarding a trial. Do you also understand what the rules of evidence are regarding a trial?
Correct.
And you understand that you're going to be held to the same standard, acting as your own lawyer. You have every right to represent yourself, and I'm not saying you don't. I'm just simply saying you will be held to the same standards that any other defendant will be represented by an attorney. Do you understand that? You have an absolute right under our Constitution to have an attorney to represent you. And if you could not afford one, I could appoint one for you. But you have elected, if I understand correctly, to represent yourself and waive your right to an attorney. Is that correct?
Correct.
All right. Then we will see you. I'm going to ask that you sign this written waiver. Sign right there where the X is. Pardon me. All right. I got it. All right, you have signed this without prejudice. Is that your name?
Without prejudice?
Yeah, is without prejudice your name?
3-301. Would you like,
Now, understand, we're not going to mess around when we come back next week for this trial.
I'm
not
aware
gonna
of
put
that.
up with any kind of foolishness where you don't identify yourself. Matthew Aldridge is the defendant. I know you are Matthew Aldridge. You're going to go to trial next week, and you're going to have to be in front of a jury of 12 citizens. We're going to pick a jury. We're going to try this case, and if you are found guilty, then you'll go on to appeals court, and then you'll have a right to an appeal.
Yeah.
But if you come in here and say that you are the attorney of fact, or that you are without prejudice, or whatever the situation is, you understand that I'm not going to put up with that kind of foolishness in front of a jury. You're going to have to represent yourself, but you're going to have to come in here and adhere to the rules. Do you understand that?
correct.
All right. And that is the ruling of the court. I'm going to show that he has signed this without prejudice, but I know him to be Matthew Aldridge, and therefore I'm going to hold him responsible for a waiver of his right to counsel. We will see you on the 15th day of July, 9 o'clock. The witness problem, the state has indicated that they may be wanting to dismiss the case against Matthew Aldridge. But Matthew Aldridge has not appeared in this court officially. So what I want you to understand is this: you can play this game with trying to say that you're the attorney of fact or whatever. And if you persist in doing so, the only choice I have is to issue a failure to appear warrant for Matthew Aldridge.
Mhm.
And if you, under oath, tell me today that you are in fact Matthew Aldridge, then we can take steps to try to resolve this matter. So it just boils down to, if you want to stand on your procedures, then what I'm going to do is, and you refuse to identify yourself as Matthew Aldridge, then I have no choice but to issue a warrant for failure to appear against Matthew Aldridge. And I'll have you step back with the officers and they'll try to identify whether or not you are or are not. You cannot defeat the ends of justice or the justice system by simply trying to say you're not who you say you are. So,
may I speak?
yes, sir. Put that microphone up so we can make sure that, there you go.
By appearing in attorney in fact, I am protecting my Fourth Amendment right.
Your Fourth Amendment right.
Yes.
What right under the Fourth Amendment are you asserting?
I have the right to my own private property, and I don't have the right. I do not have to give my name. It's basically the Fifth Amendment too. You're establishing evidence against yourself.
And I've explained to you what's the process is going to be today, correct?
I am aware. I am Matthew Aldridge, as described in the criminal complaints I've set out.
Hold on just a second. Raise your right hand and let the clerk place you under oath.
Okay.
You solemnly swear or affirm that you will give witnesses the whole truth and nothing but the truth.
I do.
All right. Now, are you Matthew Aldridge, the defendant in this case?
I am Matthew Aldridge, as described in the criminal complaint that I sent registered mail on Thursday against the witness.
I'm not sure that we have received anything.
Yes, the witness.
We haven't received anything. What exactly were you saying?
It's registered mail. I have my tracking number. It's at home. It is registered mail. It went out Thursday from.
So you're using the
Hendersonville.
government entity or a semi-government entity of the post office registered mail to send something to this court?
Well, every time I've stated something on the record in the clerk's office, you've always asked, I haven't seen nothing in the mail. And so I figured that's where you'd be looking for it.
All right. Well, you have identified yourself as Matthew Aldridge, the defendant in this case. And therefore, General Willoughby had indicated that he was going to dismiss this case based upon a witness issue that the complaining witness or the state's main witness was someone who is no longer with the law enforcement here in this area and was not willing to return based on issues that had happened. Is that still the state's position? All right.
Yes, Judge.
All right. Then Matthew Aldridge, now that you have identified yourself correctly as the defendant in this case, then the state is moving to dismiss the charges against you because of a witness problem. Case is dismissed. You are free to go.
Thank you, sir.
Case People versus Thomas Styron. Here we go.
The public defender of Otello on behalf of Mr. Styron, who stands to my left. Well, let's talk to the judge about that, right? We've been through this. Seems to be some confusion.
What's the confusion?
I've stated multiple times on the record that I wish to represent myself.
Well, I thought we got rid of that issue the last.
Yeah, I thought so too. I spoke to this gentleman right here and expressed my wish to represent myself as well.
All right. Well, if he doesn't want you, I mean, we'll figure that out in a moment. So, Mr. Styron, we're going to go through this again. What do we want to do in this case? You understand what you charged with, sir?
So, I understand what the charges are against me, yeah.
Okay, look, you're gonna have to give me straightforward answers to my questions because I've got to make sure that you understand certain things. I got to do certain things here.
From my
Do
understanding.
you understand, first of all, that if you do indeed direct, you want to smile about it and laugh about it, take him back. We'll call him out later. Take him back. You keep laughing. You laugh one more time, that's 30 days. Go contempt. Look it up. First calls the case of the people versus tyrants. Recall. State your name.
My name is Thomas Styron. Living man.
Mr. Styron, you are before the court. You have elected to represent yourself. I do have to advise you that you have 3 counts against you. The first count is that of fleeing and eluding 3rd degree under the motor vehicle code. Do you understand the nature of that charge, sir?
This is under the assumption that you're compelling me to identify as Thomas York Styron, the legal entity on this case.
I believe that you are. Do you understand the nature of the charge, sir?
I don't understand how the name you have on the case and who I am, it's 2 different people.
I have a complaint, Thomas Styron II. Do you understand that that individual is charged with fleeing and eluding 3rd degree?
So,
Do you understand the nature of that charge? You just need to answer my question.
for the record,
Take him back, and when he decides he wants to cooperate, we'll bring him back, maybe. I'm not threatening you. Say one more word, and that's 30 days. 30 days. Recalls the case, people of the state of Michigan versus Thomas Styron II. Mr. Styron, you are before the court on a felony complaint that does allege count 1. And I'm going to presume, since you do not want to answer the court's questions, that you understand English and understand what I'm saying. You are before the court on 3 charges. Count 1 is the charge of fleeing and eluding 3rd degree. Under the Michigan Motor Vehicle Code, that is a felony punishable by up to 5 years incarceration or $1,000 fine plus court cost, and would require the Secretary of State to suspend your license for up to 1 year upon conviction. Count 2 is assaulting, resisting, and obstructing a police officer. That is a felony or high court misdemeanor punishable by up to 2 years incarceration and or a $2,000 fine plus court cost. Count 3 is a misdemeanor offense of operating with a license suspended, denied, and or revoked. That is a misdemeanor as indicated, punishable by up to 93 days, $500 fine plus court cost. Your vehicle could be subject to immobilization. Since you refused previously to answer my acknowledgement as to whether you understand that, I will assume that you understand what you're charged with. You are also entitled to be represented by counsel at this and all subsequent proceedings. If you could not afford to hire an attorney would be provided at public expense to represent you in this matter. You are entitled, as indicated, to be represented at this proceeding, all subsequent proceedings, including your preliminary examination, and if the matter were to proceed by trial, you would be entitled to counsel. It is, as we have gone through the previous proceedings, the court's understanding that you do not wish to be represented by counsel, and that this matter will then proceed forth with you representing yourself. I have to advise you that in representing yourself, the court will make the presumption that you understand the Michigan court rules, those regarding both procedure and those regarding evidence. The court will not be providing any legal assistance to you during the course of those proceedings and will hold you to the same standards that I would hold an attorney representing or practicing before this court. So, with all of that, and with the court's understanding that you do not want to be represented by counsel, I will set this matter for its next proceeding.
you understand I'm the beneficiary, not the trustee, right?
That will be the preliminary examination. I will set the preliminary examination. Has discovery been provided to the defendant?
Your Honor, he was previously represented by the public defender. I don't know if they turned over the paperwork to him.
Does anybody from the public defender's office know whether or not the defendant has been provided discovery? Mr. Odetella. Thank you, sir.
Thank you. Your Honor, we have the discovery. I have not been able to share that discovery with Mr. Steyer, and I tried to speak with him and go over it, but I'd be happy to turn that over to him at first available.
All right, if you would either turn that over to the court officer so that they can provide that to Mr. Steyer so that he has the discovery, and if you could do that today, I would appreciate it.
Yes, Your Honor.
Setting the preliminary examination. Thank you, sir.
Yes.
The people would have their witnesses available June 11th. Set this matter for preliminary examination in person, June 11th, 2024, 9 a.m. That is before me. Defendant, as he was leaving the courtroom the last time, the court did find the defendant in contempt, sentenced him to 30 days. The defendant will serve that sentence. The court will sign the judgment of sentence regarding the contempt.
I don't understand how that's possible. Like I said, I'm
So
the
first of all, watch your
beneficiary. You're
language.
treating me as if I'm the trustee, or I don't want to partake in any trust fraud or anything like that. Is this a SQV trust matter involved in this? Is my social security number attached to this at all? Go figure.
Mr. Styron, or whoever you wish to be addressed as, I'd suggest that you watch yourself because there's going to be more time coming. You keep it up. You will learn how to conduct yourself appropriately in these proceedings in this courtroom and before me. You will not in any manner whatsoever
You're trying to compel me to be somebody I'm not.
or this institution.
You have no evidence
It will not
to prove that
happen.
I'm who you say I
You
am.
will not talk to me in that fashion.
In what fashion? I'm not the one being unethical.
Very good. You'll serve the 30 days. We'll see. We'll see him on the 6th. Bond continued.
Bernard, Brandon Little.
Speaking. There.
City of Detroit, this is Bernard Brandon Little. Case number SP 1513015, counts 1, 2, and 3. SP 1513091. SP 1556287, counts 1 and counts 2. SP 1556352, counts 1 and counts 2. SP 1556353, counts 1 and counts 2. Appearance for the record, please.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Mr. Little.
Bernard.
Your full name?
Bernard. I'm not the corpse. I'm not the corpse. I'm not the fiction that they send me, the caps. I'm not that caps.
So who gave you the last name Little? Your mother?
The government did.
Your mother didn't give you that last name.
The government gave it to me.
She had to tell the government, didn't she?
The government. She was the agent of the state.
She was an agent of the state? All right. What are we gonna do with these cases, Mr. Little or Mr. Bernard?
I would like to know which jurisdiction I'm being tried under so I can adequately defend myself, Your Honor.
Read the court rules. I'm not here to give you a law school instruction. Read the court rules.
What do you mean? As a matter of record, I would like it to be placed on a matter of record how I'm being, what venue you are using, Your Honor.
That's not my obligation, okay?
What do you mean it's not your obligation? It is your obligation. You took an oath to uphold. Excuse me.
Mr. Little.
Yes, sir.
Let's stop, all right?
What do you mean stop?
Don't talk while I'm talking, first of all.
Yes. Yes, sir.
All right. Secondly, it is not my obligation to read you the court rules. You're here. If you don't want a lawyer that is.
I'm not asking you to read me the court.
I'm not finished talking. If you don't want a lawyer that's versed in the rules, then you are obligated to know the rules yourself. Okay? So all of that, what kind of jurisdiction it is and all of that stuff, I'm not here to teach you that. I'm here.
You're not here to teach me, but you're here to inform me what jurisdiction that you're operating in, so I could defend myself. I'm not asking you to teach me anything. You're not teaching me anything. You're notifying me of what jurisdiction that you're operating in. Are you operating in commerce? Are you operating in military? What capacity are you trying me in?
This is district court.
That's what I'm asking. That's what I'm demanding. I'm not asking you anything. I'm demanding you tell me what process are you charging me of? Or are you charging this fiction of? Are you trying to get the bonds? I'm trying to figure out what's going on. You haven't notified me in the capacity how to defend myself.
This is district court. These are criminal cases. Read the Michigan rules of court.
That's not explaining which venue you are attacking me with. That's not what court. The court is the court. 36th district is not a venue. It's a place. It's an establishment.
It explains everything.
It's not explaining nothing. I'm asking you to explain which jurisdiction are you heading me in? That's a simple question. Why are you running from the question? That's the answer. What's the problem with you answering the question, Your Honor?
You're going to be the third person that I give 30 days for contempt of court to if you do not.
Why would you do that? Why would you do that, Your Honor?
Wait a minute. There's going to be some proper decorum in here, right? You're not going to sit here and you're not going to overtalk me. I've given you the answer to your question. If you don't like the answer, let me finish. If you don't like the answer that I'm giving you, then you file a motion on whatever you think jurisdiction is and wherever you think the case should be dismissed.
It's not about what.
Now you about to go there, all right? One more time, you interrupted me, and we're gonna go there. I said that gives you your opportunity to speak to the court through a motion. So whatever you say, whatever kind of path you want to take with these cases, I'm going to give you the opportunity to do that. But you have to put it in writing now, okay? So I can read it, the city can respond to it, and then I can make a ruling off of who I think is in accordance with the law. All right, Mr. Little?
You still, Your Honor, I'm trying to address this matter properly. Okay.
And I'm telling you how to address it properly.
But you still haven't told me what venue you addressing me in.
I just told you, you didn't like my answer. So with that being said, we're not going to go back over this again. You're going to either set the matter for a pretrial date. I'll give you an opportunity to write motions and you can put whatever you feel that the law is, the state of law as you know it, or the state of the law as it is, or with the court rules and the statutory laws and everything. You can put that in there, and then I will let Ms. Snyder or somebody from the city law department respond, and then I will make a ruling on how I feel who's on the right side of the law or not, okay?
Your Honor, am I on record?
You are on record.
I would like to make a matter of record that Your Honor hasn't answered my question properly. I'm not satisfied with Your Honor's answers to my questions. I also feel as though I've been threatened. I feel like I'm under duress right now or coercion. I like that to be a matter of record. And I'll let you do what you got to do, Your Honor.
Okay, so we have a jury trial date already set for 4 of the cases. We'll add these other cases to that jury trial date on May the 7th.
May the 7th.
And these motions, let's give you a motion date before May the 7th. Why don't you give me the motions by April the 26th? Your motion will be due. So that's a time where you, that's April the 26th, 4/26/2024, motions due, and the response to those motions, if you write them, will be on Friday, May the 3rd. The city will respond if they choose to respond, and then we'll set a final pretrial date, on May the 6th. So your next court date will be a day before the jury trial date on May the 6th. And then I'll make a ruling on the motions on that day. I'll have read your motion. I'll if the city responds, I'll read their response, and then I'll make a ruling on the motion, and we'll see if May 7th that we need that order that jury. All right. You have any further questions, sir? So you put whatever you need to put in that motion, however you feel the state of the law is. I would like to be able to read what you're talking about, because I don't really understand your position right now. All right.
We don't understand each other's position, Your Honor. That's what we're trying to come. That's what we're trying to come together with.
And that's the purpose of the motion. That's the purpose of putting all of that.
Yes, sir.
You have in the motion, so I can read it and review it. I might not still understand it. We probably are not going to understand each other's position.
Oh, you will, Your Honor. You will, because it's your language. It's your language.
I'll read it. All right.
Yes, sir.
All right, and just moving forward, let's not argue about the situation. Let's have a conversation about the situation so we can have a little bit better decorum next time. All right, Mr. Little?
It's never argument, Your Honor. It may be just agreement. You know, because see, I'm passionate about it because my life on the line.
Right.
Not only my life, my trust. So, you know, there's a lot going on that, you know, ones ain't aware of that I'm aware of, as far as them bonds and things of that nature. So, you know, I'm fighting for a lot.
Well, guys, we have come to the end of these 4 proceedings. And once again, thank you for joining me for our first Sovereign Citizen Hall of Fame compilation video. Listen, there's going to be no commentary from me on these videos. I welcome you guys to comment your comments down in the comment section, your thoughts on all 4 of these proceedings, your thought on the judges, your thought on the compilation itself. I sure would appreciate it. But with that being said, guys, this is Sovereign Citizens Hall of Fame. And for now, guys, Sovereign Citizens Court is adjourned. I thank you guys once again. Don't forget to subscribe, like, and share. And I'll catch you guys on the next proceeding. God bless.